Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Parklane Hosiery versus Shore. This case was heard in the Supreme Court of the United States in the year 1979. Let's go ahead and jump into the facts of the case. So to understand this case, we need to understand that there was a prior case before this case. Parklane Hosiery was a defendant in a lawsuit filed by the SEC. The SEC filed a lawsuit against Parklane alleging that they had made fraudulent, misleading, and false statements about a merger that they were going to be involved in. And the SEC was seeking a declaratory judgment there. The Second Circuit, in that case, ruled in favor of the SEC and found, as a matter of fact, that Parklane had made materially false statements about the merger. Okay, so that's the first case. Now, the second case is this case, and Shore is bringing a stockholders class action suit, so a class action lawsuit against this company on behalf of the stockholders, saying that, hey, these materially false statements about the merger caused us stockholders monetary damages, and so we're suing you as a class and saying, hey, these materially false statements, they're a problem here too. Now, the interesting thing about this case is that the class action plaintiff is making the argument that they should be able to use collateral estoppel to preclude Parklane from arguing that their statements weren't false. So this is non-mutual offensive collateral estoppel. And that sounds like a big word mess, but to understand it a little bit more, the plaintiffs here are saying, well, in that prior case against the SEC, the court adjudicated the fact, and the court adjudicated this issue and found that, hey, you made materially false statements about this merger. So we shouldn't, waste the court's time here. The court has already found that you made materially false statements. So that issue doesn't need to be re-litigated. It's already been fully litigated in the past. And so you are estopped. You are barred from arguing, Parklane, that those statements weren't false because the court already found that they were false. And this is offensive because it is the plaintiff trying to use that settled issue to stop the defendant from arguing about that fact in this case. And the court says, you know what, in this case, we are going to allow offensive collateral estoppel by the plaintiff. They say, this isn't going to be a situation that we always allow collateral estoppel to be used offensively, but we're going to grant the district court, vast deference in determining whether offensive collateral estoppel should be used. There's a few factors that the court delineates here and that the district court should be considering if they're going to allow offensive collateral estoppel. The first would be, could the plaintiff have easily joined the lawsuit? And here, the stockholders couldn't have easily joined the SEC lawsuit. The SEC has made it pretty clear, and the court has, that private stockholders can't join in this SEC lawsuit of this kind. Second, did the defendant have a full and fair opportunity to litigate the issue in a prior lawsuit? And they're saying, hey, here, yes, you did, Parklane. You definitely had a full interest in proving that your statements weren't false. You litigated that to the best of your abilities, but the court found in favor of the SEC. So yeah, you had a full and fair opportunity in the past to litigate this issue. And then finally, they're going to say, was it foreseeable to you at the time of the prior lawsuit, at the time of the lawsuit against the SEC, that you were going to have more lawsuits against you in the future? And they say here, yeah, it's totally foreseeable. If you made false statements about a merger, the SEC is going to sue you, but stockholders are going to sue you too. So you better make sure you argue to the most in that prior lawsuit about that issue, because if it's not in your favor, then that could be used against you in future lawsuits. Justice Rehnquist writes a dissent here, and Justice Rehnquist says, this is completely unconstitutional, and it usurps the right to a jury trial by Seventh Amendment. He says, this offensive collateral estoppel, just not a huge fan of it. The Seventh Amendment requires the preservation of the jury trial, and it requires that, we don't just toss that to the side in the name of efficiency, in the name of, conserving judicial resources by allowing prior litigated issues to be used in future lawsuits. He says, in each instance, we ought to allow the jury to weigh in on the issue. So this is a very interesting case because on the one hand, you have efficiency, the use of offensive collateral estoppel, and then on the other, you have the Seventh Amendment. And I think Justice Rehnquist does present a fairly persuasive argument that this offensive collateral estoppel is just going to usurp the Seventh Amendment and the right to a jury trial. And he says, if you're going to do this, just be transparent about it. And you're not being very transparent about it here. So to illuminate this issue a little bit more, you could think of a scenario where maybe a large company, let's say Walmart, gets sued by an employee, a disgruntled fired employee. And in that lawsuit, the employee argues, Walmart, you had a national policy that basically led to my wrongful termination. And the court says, that policy did lead to this employee's wrongful termination. Well, then in the future, should we be able to have a class of former Walmart employees that have been terminated, form together and say, hey, we're going to use offensive collateral estoppel. Walmart, sorry, you can't litigate that issue again, and you're going to have to litigate it, against us. And I think there's a few prongs here, or you won't be able to litigate it against us, the class, because your collaterally is stopped from doing so because the prior court had already found that your policy led to the wrongful termination of this employee. And, there's a few areas where you could push back here. One, you could have said, well, these other plaintiffs, this class, could have joined in that prior lawsuit. I think that's probably a hard argument to make, but Walmart would probably want to make it. Did they have a full and fair opportunity to litigate this? Probably. There's this lawsuit from one plaintiff against the company, but maybe Walmart was just like, hey, this is just going to cost us $200,000. We're just going to let this lawsuit go out, let him win. Let's just get him off our tail. But they're not really thinking about the long-term impact. And then finally, is it foreseeable that if one employee sues that your policy led to their wrongful termination, is it foreseeable that many others would? Well, quite likely. But I think that kind of takes us to the edge of where collateral estoppel would be allowed by the courts. And I think that's even a questionable thing. I think that the defendant could push back there as well. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.